Have one, if you would like.
Thank you very much.
They're fair game.
Alright, Mark. See if I can hold myself under this table. Two, two, four, right?
Back to 224, yep. Okay. We're live. Okay, this is Senate Natural Resources and Energy coming back from a break, and from our joint hearing with Senate Transportation. And we are taking up S224, and we are joined by Mr. Bradley from the Vermont Federation of Sportsmen's Clubs. Welcome.
Thank you so very much. I know it's a bit of a challenge to get us scheduled, so I really appreciate it. Thank you very much. Mike, for the record, my name is Chris Bradley. I have the honor of serving as the president and executive director of the Vermont Federation of Sportsmen's Clubs. We've existed in Vermont since 1875. We actually started our organization when white-tailed deer had been hunted to extinction. And we were then pivotal in helping to start the what is now the Fish and Wildlife Department. So we work very closely with them. I represent 42 member clubs with approximately 14,000 members across the great state of Vermont. I am in receipt of the new version of the bill, which I believe is 4.2. We had serious concerns in the initial version as introduced on section 1. That has been removed, so I'll just and thank you for that consideration. I believe the other section was section 8, but that has now been renumbered to section 9. So good heavens, the intervening sections of great boats really been out of our wheelhouse, but by having C1 got some challenges there. So thank you for dealing with that. We believe we fully understand the serious concerns expressed by the city of Gary regarding the desire and need to protect the Dix Reservoir, which is the source of Gary's drinking water. From our understanding, a primary impetus for this bill is that a fishing derby is approved for the Dix Reservoir by the Fish and Wildlife Department through their permitting process. But there was never any notice given to the city of Barry or the operators of the Barry water system that this event was to occur. We do not take the stance that there is zero risk to the Dix Reservoir when a fishing derby is held on that body of water. However, it would be our observation that history has shown that the risk is minimal to non-existent, given the Fish and Wildlife Department, through the Fish and Wildlife Board, have the ability to regulate things like the use of live bait, the use of motorized watercraft, as well as bag limits. It is our hope that all of us can see that the real threat to water systems, such as the Dix Reservoir, is not as a byproduct of the responsible use of these waters by anglers, either as individuals or as participants in a fishing derby. Just with many other activities, such as hunting, the vast majority of people who participate care a great deal about the environment. They have a vested interest in ensuring and minimizing any impact that they could have on the environment, and therefore are very conscientious about things like litter and or actions that have the potential to cause harm. This would be even more true during an event like a fishing derby, where there would be more people around that would see and then report or even intercede bad actors or bad actions. The more sinister threat to a water source such as Berlin Pond or the Dix Reservoir is not public use. It is the potential for bad actors and those that would have evil intent to consciously take actions which would and should amount to pure terrorist activity. From this perspective, the Federation worries that pushing a law such as this, or the previous effort to restrict the use of Berlin Pond, serves to give bad people bad ideas. Our concern with section 9 is the same as we had with section 1, now gone, as both sections implicate the public trust doctrine, Vermont Constitution, and 24 VSA 2295, a statute known as the preemption statute, which has served Vermont well for 37 years. Specifically, section 82 allows a municipality to control fishing by being able to deny a fishing permit, something that is specifically disallowed under 24 VSA 2295. Beyond that, there is no requirement that the legislative body must act on approval by approving or even denying. Such a request could be tabled indefinitely I have served in the Northwood Select Board. I'm well acquainted with what could happen on the select. In listening to testimony, and especially Senator Pardue, it seemed clear that the crux of the problem was not that history has shown that fishing tournaments create significant exposure to water quality. The primary issue was a failure to communicate. Very officials were given no notice of the proposed activity whatsoever, and that is a problem. To address the communication failure, as well as staying true to 24 VSA 2295, would it ever be acceptable that the sponsor of a fishing derby or tournament is required to notify the municipality as part of the permit process, without giving the municipality the specific ability to stop it, i.e. control it? Such notification will alert the municipality of the planned event, thereby allowing them to be more proactive and observant. The other section which we see a problem is with D2. From the current wording of this section, the commissioner is put into a position that she is responsible for forcing a tournament applicant to reimburse the municipality for any costs the municipality incurs in ensuring that the drinking water source is not contaminated. We're not aware of the litany of what these costs might entail. But we have a concern. Our first concern here is that the Commissioner and Fish and Wildlife Department's current responsibility begins and ends with a consideration of whether to approve a permit or not, shouldering the responsibility to ensure that the proposed event would not adversely affect fishing or a specific species of fish. Our second concern here is that it is somewhat nebulous as to what the cost the municipality incurs in ensuring that drinking water is not contaminated. Does the city of Barry have records of the nature of the costs that have been incurred to date as a result of tournaments on that body of water, and are they available? And then I did read with a great deal of interest the letter from the city of Barry concerning the water treatment and their concerns. If there has been documented significant costs associated with the operation of fishing tournaments on public bodies of water in Vermont, it would help us all better understand the scope of the possible problem. But we believe it has been proven that safe drinking water and fishing, either individually or as a result of the tournament, do not present significant risks to quality drinking water. We believe, again, the real threat to drinking water supplies is from terroricides and the purposeful contamination of public drinking water with agents that the water system was not and is not designed to manage. Those potential threats will remain until such time as the investment is made in management, which we know is ridiculously cost prohibitive. These threats, however, have little to do with fishing or fishing tournaments by the public who wish to recreate, as well as to enjoy more food security, and history supports this. Please consider changing sections A2 to require the sponsor to notify a municipality of a pending tournament as part of the permitting process, and remove the ability of the municipality to deny a permit. This seems like a logical first step, and if this is problematic, we then go to the second step, which is what is currently being proposed. Please also consider changing D2 to remove any responsibility of the commissioner of the Department of Fish and Wildlife to handle cost reimbursement to municipality from a sponsor for costs incurred. They should be between the sponsor and the municipality, knowing beforehand that history appears to show negligible impact on the water quality for tournaments or derbies. Do you have any questions?
Thank you so much. I have some questions that are percolating.
Oh, fine.
But yes, go ahead. Yes.
Hi, sorry I missed the very beginning, but are you submitting that to, is it on the website already? Not yet, okay. Please send it to
They
me.
have submitted it,
Okay.
it was 3 days ago, I believe. I have an extra copy if you'd like.
No, I'll talk about it on the website, because I have too much paper as well, see, my desk is a mess. Thank you, I'm curious, yes, I think thank you for listening when I was saying communication.
Oh, it resonated quite well. And that's the crux of this issue.
There's so many issues, not just this one, but
No, fair enough.
but I'm wondering, I hear you on, I'm looking on page 20, on D2. I hear you on the sort of, what does it mean to costs to the municipality that incurs ensuring that drinking water source is not contaminated? Is not super clear. Oh, sorry, these are cookies from Terry Person's if you want one.
Okay,
And
that's accepted.
I'm wondering. There are other costs. I mean, I think Senator Watson had a really great example the other day of like, you know, when you do a 5K race in a town or something like that, or some kind of event in a town. And the town incurs cost for parking or police or litter control or whatever it is. That there often are, you know, they have to pay the cost of cleanup or the cost of extra security or whatever. And frankly, that's something that's more of a concern for me if the town of Barry has extra costs for all the people who might show up on their land, and then they have to clean up. I've gone fishing in a lot of places in my area and seen just like horrible litter that has been left. And not always by people who are fishing, but some by people who are fishing, like bait boxes and things like that. So I'm wondering about like having, and I think I hear you between the people who are doing the fishing tournament and the municipality, and not keep the department out of it potentially, but so that the city can be reimbursed or the town can be reimbursed for the cost of those other things that incur during a fishing tournament.
If I could address.
Yeah.
It's my understanding, I mean, certainly there's a permanent, very inexpensive permitting cost for having a derby that it's
Yeah,
never.
super cheap.
It's super cheap, which is good. That encourages people to do that. It does strike me that a tournament sponsor has some responsibility for number one, public safety, make sure they're parking and adequate parking. And that actually they should be on the hook for any potential cleanup. And by notifying, hey, I'm gonna run a fishing derby by City of Barry. I'm the guy that's now in the crosshairs. It's not Michigan Fish and Wildlife, it's not the department. We now have a direct correlation between you're responsible for this and what has been done to make sure it's mitigated.
Yeah, but I don't think there's anything that requires that now. That is my understanding, or there's no penalty for them if they don't clean up.
Well, so you have a situation where the city knows exactly who to go after.
Well, but if they can't, if there's nothing that allows them to enforce it, there's no agreement, there's no contract, there's no penalty. Then what are they gonna do? It's just gonna be the city manager or the select board yelling at a fishing derby organizer.
Could this be accomplished with a simple standard memo of understanding that says,
Potentially,
I'm running a tournament. These are the responsibilities that are in front of me. This is delivered to the municipality involved. I just, you know, I don't want to get camel's nose under the tent or anything like that, but 24 VSA 2295 is sort of Vermont exceptional. And I raise eyebrows, having served on a select board, when you're giving a select board that sort of authority, even in the situation where it's a drinking water in Berlin Pond. I mean, I was involved in the Berlin Pond discussion. I don't think there's been any, and again, my huge concern, here's Berlin Pond and X marks the intake. It was, wow, that's kind of scary. But a memo of understanding or something like that, between me and perhaps the commissioner for drafting that up. It's just that I really have a problem with the municipality being given the authority to say no. Now, maybe we've run a derby and it was an absolute disaster. You're never coming back again. And
yeah, but if they don't have the authority to say no, that's another thing. Like if there's a derby that causes a lot of problems.
Oh, well, certainly the commissioner knows.
I guess the commissioner could say no, but
So if the memo wasn't, I'm just,
yeah, so I think having some kind of document that documents what the responsibilities are, and maybe that's part of the permitting process, I don't know. But, and then having some kind of recourse if things go bad.
well, I think a memo of understanding might address that. As a first step, let's see. Again, I realize, I started off by saying, I'm not saying there's zero threat here. But I am saying that by and large, fishermen, anglers are responsible. And yes, frankly, I've been on Berlin Pond numerous times. I'm one of those silly guys in my kayak that goes up to the shore and starts picking up liquor and throwing it in my kayak.
Yeah, I see that.
And I know most people like me do that.
Yeah. Go to the Dead Creek Wildlife Area, there's a ton of trash there, it's really sad, along the fishing access.
That's appalling.
Yeah.
It is appalling. And there are bad actors.
Yeah, we can
And,
go fishing there and pick up trash here.
sounds like an invitation. If you're over.
Did you have a question, comment?
Well, just thinking that, you know, if it's fishing being small
Sorry.
runs the dirt, they have liability insurance. Somebody, that they have to make sure the parking area is plowed, so people are placed to park. And if somebody slips and falls, or gets hurt, or there's some liability involved, the insurance should cover it.
I think the term sponsor has some responsibilities. And whether that's parking or public safety, I mean, certainly they're charging something above the minimal cost of having the permit. Not that you're looking to make money, because most of these things are fundraisers. But to have an event and to not make any allowance for garbage pickup or public safety for making sure you're parking, then there's something amiss there, I think. The properly run with an identified sponsor who has communicated with the town, and also the commissioner as part of the permitting process. I think it addresses the major issue, one of the major issues, which was communication. And I'm frankly appalled that could happen with nobody picking up a phone or an email or something to say, hey, by the way.
So the questions that I have, that's okay, of course. I think it comes back to a different topic, but before I get into it, by the way, thank you. Thank you for your thoughtful engagement with the issue and acknowledging the conflict. One of the things that I am coming back to as I continue to understand the situation is that particularly for this kind of situation, there was an issue around access. And so there are some fishing access points, but the vision of having a tournament or a derby where there may be a lot of people, and so there are people spilling out from that access point onto the shoreline becomes potentially a trespass issue. I guess I'm feeling the tension between the use of the land around it as well, which I realize is probably an issue that you might have to engage with another context around just like the posting of land.
Oh, I have some strong feelings.
Yeah,
I sat in the day in Cummings where they got hunted over here.
Yes.
314 of them. Aren't you, if the issue with trespass, I think that is kind of touched upon, if I'm not mistaken, the form shall require the applicant to identify an access point to waters and participants of the tournament.
Yep.
And I see that is already here.
Are you not objecting to that?
Private property is private property, and I have very strong feelings about that. And you never go onto anybody's property unless you give her permission, especially if it's supposed to be no trespass. My experience has been properly posting, approaching a landowner and explaining who you are and what your purpose is. Generally leads with favorable reaction. It's the scofflaws that will just thumb their nose at everything and cause And then throw litter and that sort of thing, that really gives good people a blackout.
Okay, well, thank you, appreciate your testimony. Any other questions at this point? Okay,
Thank you so very much.
yes, thank you. Appreciate that.
Especially juggling things around.
Yeah.
And I'll probably see you again when that poster goes tomorrow.
Yes.
Thank you so very much.
Thank you. Okay. Just to, before we leave this as a topic, I just want to flag that my thinking around this is, I want to have some committee discussion around the direction that we want to go with this. I don't necessarily want to have that right now, but I want to plan for some time for, because I think there's a lot of pieces up in the air about what we do with aquatic invasive use on access points and our and also what we want to do with this section. So before we see any new draft, want to get your thoughts about the direction of where we should go. So anyway, there we are. I anticipate that for next week. So for now, I'm gonna put this aside, and we are transitioning now to talking about Act 250. And I know that where we are in general as a committee is there's a, I'll speak for myself, there's a range of experience, right? Like that. I mean, I was here a couple years ago when we did a sort of 101 on Act 250. That was very helpful. And so I've asked Ellen to come back and do basically that again, just to especially as we're looking at 325 and then Act 181, which sits on top of that. To give us the basics of like, this is what Act 250 is, this is how it works. Yeah, so that's where we're at. Okay, good morning.
Morning, yeah. Ellen Chaykovsky, Office of Legislative Counsel. So I am here on an overview of Act 250. Act 250 101. I did provide a slide deck. So I have a couple of slides. So I'm going to share my screen and all right. Maybe yes. There we go. All right, so this is a brief introduction to Act 250. Act 250 is the state land use and development law. It is codified in 10 VSA chapter 151. So when you see it in legislation, that is usually the citation that is provided. We don't generally refer to laws by their act name, but Act 250 has been special in that way for 6 years. So that is how it is known anecdotally. So Act 250 is a state land use and development law. Broadly, it requires permits for construction of large development. The operative language on what is required is in 10 VSA 6081A, which reads, no person shall sell a subdivision, commence development, or commence construction of development or subdivisions without an Act 250 permit. So the really operative language here is the definitions of development and subdivision. And those are what we also refer to as the jurisdictional triggers, what triggers the need for an Act 250 permit. The definition of development is quite long. It has about 12 different definitions. The ones that we talk about most frequently are highlighted in yellow, but all these other things are part of the definition of development, which would trigger the need for an Act 250 permit. So they include the construction of improvements for commercial, industrial, or residential use at or above the elevation of 2,500 feet. You will see throughout that largely what the trigger is here is the construction of improvements. So we're talking about construction. The second bullet is the one that gets talked about a lot. the construction of improvements for any commercial or industrial purpose on more than 10 acres of land, or on more than 1 acre of land if the municipality does not have both permanent zoning and subdivision bylaws. We refer to this as the 10-acre town, 1 acre town distinction. In towns that do not have zoning, construction for a commercial purpose on more than 1 acre of land triggers a need. If the town has zoning, it is on 10 or more acres. There is also this fun option for towns that have zoning that they can opt to be a 1 acre town. So there, Waterbury has been a notable example of that. The theory behind this is that towns that have a zoning program do review of smaller projects, and so only larger projects on more than 10 acres trigger the need for state review. The inverse of that is true that on towns that don't have zoning, 1 acre is a smaller threshold that requires a permit.
So does that.
Quick clarification. This list, does it reflect the code in Act 181 or not?
It does.
It does reflect, okay.
So,
Let me try and.
well,
I was thinking the same thing.
so this is as the law currently works. I'm not planning to talk about 181. We can if you like. I'm currently just talking about the definition of development and what is defined
Okay,
as development.
okay.
Yeah. Yeah, so
So I have a website, another question.
Yeah,
So. Under that second bullet, I'm just curious. So, it's a 1 acre town, if municipality does not have both permanent zoning and subdivision bylaws. I guess I'm wondering about those two things. Do some towns have zoning but not subdivision bylaws?
yes,
That's a thing?
Yeah.
Wow,
and some towns do not have permanent zoning.
they have temporary
They
zoning?
have interim zoning.
Wow, well, so like it would expire?
It does, yes, and there are towns that have used that. You can, generally, you're supposed to use interim zoning on an interim basis as you're developing further plans. There have been instances where towns have sort of re-upped their interim repeatedly.
They're
Yeah,
interesting.
so yeah, so the land use review board maintains a list of those towns that qualify as having both permanent zoning and subdivision bylaws.
Thank you.
Yeah. Commercial here is a very broad definition of commercial. It includes things that you think of historically as a commercial enterprise, like a store or something that is doing business for money. However, there's case law that under Act 250 has a broader definition and can and does include nonprofit organizations, religious organizations, if there's an exchange that happens. So it is broader here than maybe traditionally known. The next bullet is the construction of 10 or more units of housing, including construction or maintenance of mobile homes or mobile home parks with 10 or more units within a radius of 5 miles and within any continuous period of 5 years. So this is known as the 10 by 5 rule. 10 units within 5 miles within 5 years.
what does within 5 years mean? Like, you build a house and then a year later build another and then a year later.
Yeah.
So all 5 have to be, all 10 built within 5 years.
A permit is needed if you are going to construct 10 or more units within 5 miles of each other within a 5-year period.
I okay.
Yes.
Which if I can comment or editorialize a little bit, that was one of the reasons why we sort of inadvertently were encouraging sprawl. Because if you could just get a little further out, then you don't trigger. But with 9 units, get a little further out, and then you don't trigger Act 250.
Anytime you set a limit in a statute, people will find a way to avoid it and do creative things. The intention here, I think initially was to avoid the problem of people doing that by saying, well, I'm building 10 units over here, but a little bit farther down, I'm building 10 units but actually they're gonna share a parking lot and be actually one major development that I was just trying to avoid. This is a very old part of the statute, and whether or not it still applies, whether it has had unintended consequences is something for you all to discuss.
And that was not changed in 181?
No, it was not.
Oh, you're sad. I felt like it was, because it came up so much.
The next bullet is the construction of improvements for a governmental purpose, so a municipal, county, state, or public purpose. If the project involves more than 10 acres. So, state projects have to go through Act 250. There is a distinction here. There is a different definition of involved land for public projects than there are for commercial projects. Involved land, if it's a commercial purpose, is the entire tract of land. For government projects, it is if 10 or more acres are being disturbed. So, what that means is that it generally requires a higher level, more disturbance for the government to trigger Act 250, but parts of the government do have to go through Act 250 and get a permit if they disturb more than 10 acres. And so then the rest of these are a little bit less well known. Construction of a support structure that is primarily for communication or broadcast purposes, and that extends 50 feet or more in height above ground level or 20 feet above the highest point of an attached structure. So telecom facilities, they have the option to go through the Act 250 process or the 30 VSA 248A process. And other committees are working on language right now related to this, and there are telecommunications companies that still use the Act 250 process as opposed to the PUC process.
Interesting.
You may be hearing more about that in the coming weeks.
I suspect we're gonna see something after crossover on it.
Yes.
Yeah.
So the exploration for fissionable source materials beyond the reconnaissance phase or the extraction or processing of fissionable source material triggers the need for an Act 250 permit, as well as the drilling of an oil or gas well, as well as withdrawal of more than 340,000 gallons of groundwater per day. And then the addition from Act 181 is this jurisdictional trigger called the road rule, but it's the private road jurisdictional trigger that says the construction of a private road longer than 800 feet or a combination of roads longer than 2,000 feet will trigger the need for an Act 250 permit. That does not take effect until July 1 of this year. And the statute on this specific jurisdictional trigger is significantly longer than one sentence and has a lot more detail to it. So those are all the parts of the definition of development that trigger the need for a permit, but there are exemptions embedded in 10 VSA 6001 and in 6081. There's also a definition of subdivision, and this is one we talk about a lot less, I think, but a subdivided land can trigger Act 250 when the land is partitioned or divided for the purpose of resale into 10 or more lots within 5 miles within the jurisdictional area of the same district commission within 5 years. So again, it's a 10 by 5 rules for the subdivision of land into 10 or more lots. There's also another thing though for towns that don't have permanent zoning and subdivision bylaws, it is actually the subdivision of land into 6 or more lots within 5 years. Then there's also this interesting sort of caveat, which is if the sale is going to be by public auction, it will trigger the need for an Act 250 permit if there are 5 or more lots within 5 miles within 10 years. So, is an Act 250 permit required? This is a question I get asked almost daily. And I have this very short, a brief and incomplete analysis for illustrative purposes. This is not legal advice. But if you're wondering to yourself, is this going to trigger the need for an Act 250 permit? Here is some of the common questions you can ask to determine if it probably will need an Act 250 permit. The big caveat here though is that Act 250 is a statute that's designed to be site specific, to acknowledge that all different sites are different. So even though it's the same type of structure that may be going in, there may be site specific features that would trigger the need for permit review. So this is this is, if you need more information on this or have questions, the Act 250 district coordinators can help you as well as, the land use review board has staff that this is their job is to answer this and do this analysis. So when you're asking this, when you're trying to determine what you should ask first, is what is the purpose of the development? Is it for a commercial purpose? Is it for a governmental purpose? Again, including county, municipal, state, public. If it is for a commercial purpose, does the town in which it's located have permanent zoning and subdivision bylaws? Is it a 1 acre town or is it a 10 acre town? So if it's a commercial project in a 1 acre town, is more than 1 acre of land involved? If it's in a 10 acre town, are there more than 10 acres involved? For a commercial project, involved land includes the whole tract of land. So is the project going to be on a parcel of land that is greater than 10 acres in a 10 acre town? Or larger than 1 acre in a 1 acre town? If the answer is yes, if an Act 250 permit is required, the applicant must demonstrate that the project will comply with all 10 criteria of Act 250. It says, review these requirements and address whether or not your project has taken them into account.
Can I ask you a question? So when measuring the acreage, does it include existing structures that might be already have been built?
Yes.
Okay, so if there's a shopping mall already in a place and they're raising it and putting in a bigger shopping mall. Something like that, the land that's already built on is measured as part of the 1 acre or 10 acres.
For commercial development, it is the physical size of the tract of land that it will be built on,
Okay,
just the parcel size.
Another question here?
So if somebody owns timberland. So some of it being about 2,500 feet, do we have to have an Act 250 permit to cut their logs?
Forestry is exempt from Act 250. But
Yeah.
if some of it is going to take place above 2,500 feet, yes, it may need a permit.
So if they stay below the 2,500, I don't know how you do that, even the altimeters or.
They know where every square
I
foot
know.
out.
They can see it, they can see everything you do so, okay.
Just since we're talking about exemptions, farming also exempt?
Farming is exempt from Act 250, again with the caveat above 2,500 feet.
Yeah.
So you have heard of the Act 250 criteria. What are they? They are listed as the 10 criteria. There are 32 sub-criteria. So when making an application, the applicant has to look at each of these criteria and address them. They need to address whether or not they are on the site. So while all 32 of these exist, every site might not need to address every criteria. A good example is primary agricultural soils. The criteria 9B asks if the development is going to destroy or convert any primary agricultural soils, which are mapped for the whole state. If there are no primary agricultural soils, the applicant just needs to address that we have investigated, there are no primary ag soils on this property, we do not need to do anything under this criterion. The same is true as for a number of other ones. Including the one that was added most recently in Act 181, criterion 8C, forest blocks and habitat connectors. That criterion asks, will the development happen within a forest block or habitat connector? These are, I don't know if they're fully mapped, but the municipal maps have been required to have these on them for almost a decade. And so looking at those maps, will the development take place in a forest block or habitat connector? If not, you probably don't need to address anything under that criterion. Okay, so what is the basic process? So, as I mentioned before, any person can request a jurisdictional opinion from the district office if they don't know that that a project will need a permit. So they can submit a request. That request goes to the district coordinator who reviews what the basic proposal of the project is and whether or not it meets the definition of development or whether it fits under one of the 30-something exemptions. Any person can request this, whether they be an applicant, a proposed developer, or a member of the public. So once it is established that a permit will be needed, you submit your application to one of the 9 district offices. They are largely, the districts largely fall around counties. Most of them have 2 counties under the district, but like District 4 is mostly just Chittenden County because that's a very busy district. The district itself is made up of 3 district commissioners and their alternates. District commissioners are appointed by the governor and have terms. They are basically volunteer. All they receive is a $50 per diem for days when they're holding the hearings on any permits, and so they only receive a nominal $50. There is also staff, though, that staffs the district to assist them. There's at least 1 district coordinator per district, and then there's also a few members of support staff, like a legal technician and administrative staff. So, but it is a pretty lean operation, largely, given that there are usually around 400 or more permit applications a year. So the district coordinators assist the district commissions who are working very limited amount of hours. The district coordinator is a full-time position. They review applications for completeness and communicate with the applicant about what other information they're going to need to provide in order for their application to be accepted. Most applications do not have a hearing. The Land Use Review Board, which is the overarching administrative part of the Act 50 process, which I actually didn't include in this slide, but they issue an annual report every February 15th on what has happened in the Act 50 program in the last year. So you're about to get that report in a few days, and they will have the statistics of how many applications there were last year, how many of those had a hearing, how many of them were appealed, how long they took. They keep all those statistics, and they update them every year because you all are very interested in seeing them. So most applications don't have a hearing. I looked at the annual report from the prior year. There were only 11 hearings in 2024 out of more than 400 applications. The rest fall into what are called minor applications or administrative amendments. So there's a distinction between a major application and a minor application. Minor applications on their face do not raise any significant concerns under for potential impacts under any of the criteria, therefore not needing a hearing. Members of the public can submit comments, however, or people can raise concerns about whether a project actually is going to have major implications, and then they can request to have a hearing. If a hearing is needed, that's when it's considered a major, and the commission itself hosts a public hearing on the application. If there is a hearing on an application, members of the public are allowed to attend and provide comment, but only a person who's granted party status can submit evidence and participate in the hearing in a more full way. The district commission, people can apply, and only a person with a particularized interest in a specific criteria may be added as a party. So a person needs to have a particularized interest, an interest specific to them that is not considered an interest of the general public. That usually means that the land that they own is involved, and they have to apply for a specific concern with a specific criterion. So they can apply for all, to be under all 10. That is actually fairly rare. Usually they say criterion 8, the aesthetics, my view shed is going to be impacted by this, or my property is adjacent. I'm concerned about runoff, so I'm concerned about criterion 1 and stormwater. And the district commission just determines what things they're actually allowed to provide evidence on or testimony on. The district commission may approve, deny, or approve an application with conditions. Less than 1% of applications are denied. The majority of them are approved with conditions. Conditions allow the district commission to say, all right, you are going to have some runoff because of this project under criterion 1. What are the stormwater features that you're going to include to address that? And they will build that into a condition in the permit. Some applications are appealed. If they are appealed, the first review goes to the division, the environmental division of the Superior Court, where the case is heard de novo. They do not, they put on the case as though the district commission level really happened. Parties present their evidence. The only people who can appeal are those who participated in the hearing below and were granted and maintained their party status. So there is a requirement that if you want to appeal, you have to show up early, apply for status with the district commission and participate in that hearing. And you can only then appeal on the criterion that you have participated on. After that appeal of the environmental court, you have the option to appeal to the Supreme Court. And there are around a dozen or so appeals to the E-Court every year, and less than half of that to the environmental court, or to the Supreme Court, I'm sorry.
A dozen appeals to the Supreme Court, do they?
No,
they don't-
no,
To the.
far less than that, yes.
Okay.
Yes.
To
Somewhere between,
the E-Court,
yes,
I like that, the E-Court, and are they, does the Supreme Court, if they get appealed, do they also hear it de novo, or do
No.
they look, okay? And. We just were hearing some testimony about Act 250 as it relates to transportation projects, so, but more generally. You know, one of the arguments they were making and that I've heard from others is that, you know, there are all these other permits you have to apply for and you have to do that first before you go to an Act 250 permit. Because those permits help you make the case for meeting the 10 criteria. So do you have a sense, first of all, is that true? You're nodding, but is that true? And then second of all, is that required and what about the timeline for that kind of thing, do you know?
what do you mean, is that required?
Is it required that they get the other permits first, or is that just generally how people do it?
If they're going to use the permits as evidence under the criteria, yes, they have to receive that permit first.
Okay, and then do you have a sense of the timeline for the Act 250 process? One.
Yes, and I would encourage you actually to hear from the LURB when they issue their report next week. They track how long each permit takes, and I am nervous to say the statistics out loud, but I believe it's somewhere, well, we could get it right now, but I think it's somewhere around 80% is within 60 days.
Okay.
And then they have the sort of tranches, and part of that is because minor amendments or minor permits are very quick to issue because there's no hearing, there's a public comment period, and they issue after that, and administrative amendments can happen within days. Administrative amendment is when there's already an existing Act 250 permit and the permit holder needs to make some small change that is not going to trigger much, repaving the driveway or something like that. So like that, those can happen very quickly, and then very few majors can take up time.
Okay.
It is on your website under the reports page, and it is on their website, the annual report that has all those
It
statistics.
has already been issued?
No, last
year's, okay,
Yeah.
next year comes next week,
Yes,
or this year's comes next week.
Yeah.
Okay, cool.
Thank you, this was great.
Yeah, it's really helpful.
And, in part of, I'm wondering, like, if we had more time, would you have more to say?
I mean, I guess I didn't talk about the LURB at all.
Okay.
But I was talking about what the actual process for Act 250 was, and the LURB is not directly involved in most of it.
Yeah,
The district commissions function as quasi judicial bodies, and they are the ones who issue the permits, not the LURB.
well, I'm wondering if we should have you back for, it's like a round two, like anything additional. But in any case, we are running out of time, just to preview tomorrow really briefly. Highlights of tomorrow, we're gonna have more testimony on 223, the study that we looked at this morning, and then we have a joint hearing with Senate Economic Development again. I think we're gonna do that one in 10. And that the theme there is about tier 1B opt-in versus opt-out.